I'm Jadena and Gustav Esquire. You can call me Attorney J. And this is Rise and Thrive, Divorce Coaching with Attorney J. So today we are going to talk about a very sensitive topic to so many, and this is parenting. So time sharing, custody, all of those things. And we understand, right, with real life, okay, so not even considering the courts, in real life, you're there. You know your interactions with your children. You know the other parent's interaction with the children. It's not a question, right, of what you know and how things go. However, we always have to consider that once we get into divorce, there's a third party involved. That third party does not know what you know, and they just cannot. They cannot be there for your day-to-day life of your child. However, they do have to make an objective decision. How are they able to make this objective decision? They make that decision by what they call the best interest of the child. So first, that's the standard. Across the nation, it does not matter where you are. The standard is the best interest of the child. Now, how would a court who's not in the child's life, who does not see that the other parent never comes when they say they're going to come, that the other parent is not as hands-on. The other parent, when they show up, they're either on their phone or they take the child. They're supposed to have them for the whole weekend, always dropping them off in the middle of the week, the middle of the weekend, never keep all their days. They don't see all of that. So what is it that they use to make this determination? And also, how is it that you can prepare yourself for that? How can you be strategic enough to articulate what it is that you see with what they're going to look for? So that we know is the standard best interest of the child. Now, okay, that's the standard. Now, what is it that they do? So I'm going to be looking back and forth because some states have over 20, like Florida. Other states have 15. So what we did is we looked over all of the states and we broke it down to the most common factors. So wherever you are, you're going to see these factors. Now, one thing to remember, though I'm going to list the factors for you and we're going to go through them, talking about ways that if it applies to you, how do you present this? So even in your arguments, for those of you that are going to represent yourself, where you are more than equipped to represent yourself a lot of times in your own divorce proceeding, how do you use what they're looking for to already set up your arguments, to set up your position? So that's what we're going to discuss as well. Another thing to remember, even while we're going through this, the courts do not want to make the decision. Yes, they have to have a standard. They have to have something that they go by, but they actually don't want to make this decision. How do I know that? And how do you know that? Because doesn't matter where you are, mediation is an automatic thing that they include when you have a family law matter. Doesn't have to be divorce. It can be custody, child support, all of those things. There's mediation. Why is that? Because the court does not want to be involved in family decisions unless they have to be, okay? So I believe going over these factors that the court is going to consider is important because like I advocate for, and a lot of attorneys advocate for, is you all coming together to make the decision on your own. The court believes you at some point were able to talk to each other, deal with each other, and now, yes, I will get involved if I have to, but maybe you should go back there to that place where you were able to communicate, or go to that place where you yourself are considering what is the best interest of your child. Two people that are the parents coming together and making a decision is always going to be the best interest of the child. However, we're aware that there are some couples, when you're divorcing, you can't even communicate anymore. And if you communicate, you're communicating through emotions. That's something that we're really going to address in multiple videos. It's about emotions. Why are we not talking about, the true impact of divorce? It is like a death. You're in mourning. We understand that. We get that. But not only are you in mourning, but you're also trying to understand what happens next for you. A lot of people are like, I don't want to go back, on the market. I don't want the single world. This is crazy. But we have to understand that even when you're going to be emotional, I never tell anyone, oh, don't be emotional. Put on your big girl's panty, put on your big boy underwear. No, I don't say that because I am not aloof. I understand that there's a lot of emotions, but what I do say is let's not make any decisions within your divorce based on your emotions, because then you are setting yourself up for a very tough situation after the divorce is done, because you'll be looking at the order and you're like, what is this? This is not what I wanted. This doesn't make sense. But that's why you got to take a moment when you are in tears or you're angry. Don't make any decisions regarding your divorce at those times, because it's not going to turn out right. Okay. So on my chapter on divorce, I do want to read a quote that I have. I don't remember it by head right now, but I want to read a quote that we have by Mr. Green. Hold on. So for the chapter in the book that I wrote, Divorce Like a Boss, and we're going to reference that, right? Because that's my thinking, my words. So that chapter I call Friend or Foe, the Enemy of the Divorce Process. And I want to go to, it's just the first page, and it's a quote by Robert Greene, who was the author of. So for the chapter in the book that I wrote, Divorce Like a Boss, and we're going to reference that, right? Because that's my thinking, my words. So that chapter I call Friend or Foe, the Enemy of the Divorce Process. And I want to go to, it's just the first page, and it's a quote by Robert Greene, who was the author of, "You cannot repress anger or love or avoid feeling them. You should not try, but you should be careful about how you express them. And most important, they should never influence your plans and strategies in any way." Did you get that? So yes, you will have them. You can't really repress it. You can't stop yourself from feeling anger and love. However, you can and you should prevent yourself, stop yourself from making any decisions. Do not let them influence your plans and strategies in any way, okay? And for us, we're talking about in the context of divorce, okay? All right, let's get to it. What are the factors that the courts are going to look at, and how should you be considering these factors? Okay. So number one, the physical safety and welfare of the child. So what are some of the things they're looking at? The individual, so the two parents who can provide food, shelter, health, and clothing. That's self-explanatory, right? It's always going to be the health of the child. Now, I know some people are like, well, when my child goes to the mother's house, they don't have as much food. She buys fast food. I cook food. I think that I'm the better parent because I cook food. The court is not looking at that. I can tell you that. Does the child eat? Is the child going to bed hungry? Are they malnourished? Are they not going to the doctor or their appointments if they're with this other parent? Will the parent, purposely neglect the child? So that's what they're thinking about. So not I'm better or one house is better, even for the sake of roaches. Like, oh, I don't have roaches in my house, but the other parent has roaches in their house. The court is not considering that. There's rape. There's other things that you can do for roaches. Come on. That's not going to be a factor, but I can understand why someone would say, well, I think that it's just more healthy in my house. But that's not what they're talking about. They're talking about, is the child's life in jeopardy with this child, with this parent or the other parent, okay? And if it's equal for both, the child's not in jeopardy, okay, that goes for both sides, okay? So consider it like a check, okay? So as we go through this, we're going to consider it a check on each side. Number two, love, affection, bonding, and emotional ties existing between the child and each parent or person available to care for the child. Now, again, That's not difficult. But remember, you have your subjective opinion. You know what that means. You feel that my child is different from every other child. My child needs hugs. My child needs kisses. My child needs to be affirmed every day, or they're not going to perform as well in school, or there's going to be complaints. We get that, right? And the court understands that there are different approaches and children are different, but the court is not going to nitpick and differentiate between the parent who's saying you good, and spending time, sometimes just being there, right? Is showing that there's a bond, making sure that they're eating, asking them about homework. Those are things that bond parent and child. So yes, you may kiss more, hug more, say affirmations. The other parent is physically there. The other parent shows up, to school activities. That's ways of bonding. Okay. The parent may just pick them up from school and drop them or take them for ice cream. That's bonding. So yes, you may do more, or the other parent may do more. It does not mean that you have less. It's just, is that something that's neglected? Meaning you can say there's no love, affection, bonding, or emotional ties that exist. That is the real distinction, okay? So if you're saying that on this side, yes, on that side, no, not at all, that's a different case. And the court will consider that. Number 3, so let's say that in one residence, it's the same thing. So love, bonding, affection with siblings. So half siblings, step parents, stepchildren, and things like that. That's something to consider, because remember, the court does not want to take a child and completely separate them away from where they're safe, where they're loved, for the exact opposite. So if there's children, that's not going to really go against you. That's actually something that supports you having time with your child, because I have children that's similar in age, not too far in age, and they love them. They get along well. That's important. And the court wants to see that. Now, let me pause right here. This is number 3. I'm going to pause right here, because remember, the starting point is 50-50. Like, you guys should share your child, try to spend as much time as possible with your child, okay? So that's usually the starting point. Now, you have to, in going through these factors, see where does the scales tip. Does it remain equal throughout? Then most likely you're going to get a 50-50. Does it lean more towards one and it is not as favorable towards another? Then you're looking at a little bit of an unequal time sharing. But these are important because this is the way that the judge is going to make a decision. You may say, oh, I don't think that should be considered. Stepsisters shouldn't be considered. They're not my kids. So where you may say, well, that's a stepchild, these are same mother, same father children, I think that should have more weight. The court is looking at your child's whole life. So not just, oh, well, I favor mother. A lot of people say that. Well, they favor the mother anyway. That's not completely true, and it's not completely false, because there is, that maternal aspect. There is the majority of parents who are there with the children while the other one is working more is usually the mother. So is there this knee-jerk reaction for mothers? For a lot of people it is. But I've seen over this decade of representing family law clients, I've seen judges who start off on father's side, and it could be their own personal reasons, could be a very bad case, could be whatever. But there are more father-leaning judges, there's more mother-leaning judges. So that's why these factors are so important, because it gives them that ability to be objective. Take the facts as they are. But if you already know the facts now, you can now position yourself. You know that when you go and you talk to an attorney, hey, I'm looking at these factors. I've already written out, my whole breakdown of the factors and what weighs in my favor, what weighs against me. And I think you all should be doing this, right? You should all be doing this with me, going through and saying, does this apply or not? And how does it apply? Number 4, the child's need for permanence, okay? So with that, they include the need for stability, the continuing relationship with the parent, siblings or other relatives or any significant purpose. So even if it's a grandparent that lives in the home, an aunt, an uncle, but they're very close with that person, that's what the court is going to consider at number 4, permanence. Can we keep the child in a stable environment? Because we know that ripping a child out of an environment they're comfortable with can have some very serious effects on them. And we'll talk to child therapists and a lot of mental health professionals that'll come on this channel to have that conversation, the impact that it truly has on children, the way that we tell them about the divorce, the way that we ourselves go through the divorce process, and then how we make those decisions. So they want to make sure that we can keep things as normal as possible without robbing another parent of real time that they should be spending with their child. So I think we can get that. We can get that point, right? All right, number 5, the child's sense of attachment, including their sense of security and familiarity, and continuity of affection for the child. It kind of builds in with the others, and it sounds similar, but it's not saying generally. The first one, number 4, was talking from the more objective perspective of what you as a parent or the court or an adult what you show is a consistency for that child, right? So we want permanence. We don't want it to be too unstable. Number 5 is considering where the child, what is it that the child expects? You know, what do they need? Have they expressed anything, or is there anything that is special to that child that will make you believe, or that the court should know about, that shows you, or that would explain to the court that that child actually requires more stability or continuity? They have to be in familiar situations. And for example, what does that look like? So children that have diagnosis of special needs, different conditions, it doesn't matter the condition, but if they have a condition that causes very extreme reactions to change, that's going to play a bigger factor than some of these other things that we're going to go over, because you have to consider and take the child in based on who they are, right? There is no cookie cutter child. No, every child is different. So when they go through this, they're going through this based on your child, not based on anyone else. These questions are being answered based on your child. So if there's a special need or something that caused them to have a very extreme reaction to change, to the unfamiliar, then you want to really point this out to the court and make sure that your attorney understands the importance of this factor, because it will make a big difference. If the other parent, and I mean, think about those parents, and I've had cases where parents lived in 2 different states. So that would require the child for the first time having to leave the state, the home, the people they're comfortable with, and go to a whole new environment, right? So with that, what are some of the things, and this is just a little bit, what are some of the things that you would do? You would suggest that, okay, because of my child's condition, we need to put a plan in place, a reunification plan. That, let's say if this is a parent that they knew and that went away for a long time, or a parent that they never knew and now that parent is stepping up, you can ask for some reunification plan to be put in place. So, you know, more, they don't travel yet, right? They don't travel immediately. They're going to do visits here, wherever they're comfortable. You visit them there for a period of time. You may, after a while, and I can't set the time, but after a while, then, you know, you can take them, and if you're traveling, you'll be in a hotel with them. At least they realize, okay, I'm not home, I'm sleeping somewhere new. How do they react to that? From there, you gradually get to the place of where they actually leave the state and go live or do overnight visits with that other parent. So that's a way that you can actually suggest a resolution without just saying, nope, I don't want it, because the judge is not going to accept that. I'm telling you right now, the judge actually start going against you, or they realize you're not reasonable. I cannot rely on you to provide me with rational and an objective perspective, even though you have your emotional, you have your subjective, but you should be able to, and that is a very powerful tool that people don't recognize. You should be able to provide alternatives to the court. You should be able to, and at the end of the day, it's still what you most likely want. But if you can present that to the court realizes, oh, no. You're a rational person. You're an objective person. You're not being emotional and you're not being vindictive. That's how it comes off. And it plays very well with every judge, okay? But it has to be genuine, okay? All right, number 6, the capacity. All right, so now this is focusing on the parent, okay? We were talking about the child, but this now we're going to do a few questions that's focusing on the parent. And I know a lot of you want to hear, what about that? All right, so number 6, the capacity and disposition, meaning the way that they are, what's accessible to them. So their disposition of each parent or person available to care for the child, to give them love, affection, guidance, to continue education and raising that child. What does that look like? So let's say that you feel that other parent is way too violent and aggressive. You may already have a domestic violence case against them or something like that. You would argue that that other parent is unable to provide guidance. They're unable to provide affection and love because when you were together, they were aggressive or abusive to you and the child, or you in front of the child. So that's something where facts matter. You're pointing out those things. Now, we're not just throwing out lies, right? We're being honest about it. What is it about that parent that you can prove? Not just feel, not just say. What can you prove to show that parent does not have the ability or the capacity? And you always want to use the words that the law use, okay? So they don't have the capacity and the disposition to provide the love, affection, guidance, and continued education that the child will need. And you want some hard facts. So you can say that, whenever the child was with them, they were failing. They did not require them to do homework. They did not go over homework with them. They leave them by themselves. The child is calling me saying they're scared because the other parent left them. Like, that's hard facts, right? And you want to document it as much as you can. So if you're on a video call and you're going to tell the court you want to submit this, you're on a video call where your child is actually crying. You didn't set it up, because we're not setting anything up, okay? We're not playing those games. But you didn't set it up, but your child is calling you. Your child's crying, saying, I'm here by myself. I know I'm supposed to be with the other parent, but I'm by myself. I'm scared. Can you come and get me? Those are things you want to use, okay? Number 7, the home environment, okay? So the home environment, is it safe? Is it nurturing? Is it something that you would, and anyone objectively, not just you subjectively? Remember I said, I put perfumes everywhere. I put bright colors because I don't, not those things, right? Because those are just your idiosyncrasies. That's just your specific things. The court is going to try to be as objective as possible and understand everybody don't have the same means, right? You may have more money than the other parent. That's why you can provide more than that other parent. But the home environment, is it hostile? Is there drunkenness? Are they drinking all the time? Are they smoking? Does the child have asthma? Is there abuse, fighting, a lot of vulgar language, cursing? Is the child nervous and very uptight when they go there because there's other individuals that live in the house and the parent is bickering with that person? Or even if other people are bickering, but the parent is unable to stop them and it affects the child mentally, physically, you need to bring those things up, okay? So that's more of what the court is looking at. Not just, well, the child said they don't want to go because it's boring. No, that's not enough. Boring is definitely not enough. All right, let's keep it going. All right, 8, the stability of the family unit in the presence or absence of a support system within the community. So the stability of the family unit. Now, this is when we're talking about you as a parent, who do you have around that support you with that child. So if you had to run to the store, you had to do something, who's going to step in? And do you have anyone to step in that is familiar with the child? Or do you always have to go to care.com? Are you always having to get an outside person that's introducing them as a babysitter? You know, aunts, uncles, cousins, play cousins. When we say play cousins, people that are close family friends that they see all the time. Or do you have that type of support? If for some reason you're wanting to, and we're going to talk about that in a totally different video, but wanting to leave the state and you want to go somewhere else for whatever reason, you have to have a very good reason, right? Because if you're taking them away from their support system, the court doesn't like that because it can actually have negative impact. Usually ask specifically, do you believe that there's any mental health issues with the other parent? You need to be honest, not because the person pop off and get upset. That's not enough unless getting upset actually has some negative impact towards a child, towards you, or things like that. But the person's aggressive. I don't like the way they talk. They talk a little too aggressive to the child. That's not enough. Okay. Is there any issues with drinking? Is there any previous mental health? Have they ever been Baker acted? That's something to consider, because you're not just going to say they've been Baker acted. You want to try to identify the conditions that cause them to have that mental breakdown, because then you can connect it with your child. You can connect it with what it may bring upon, or whether it may bring that again, if you can, right? If those facts are there. The home, school, and community record and history of the child. So any health or educational special needs of the child. Who's able to facilitate that? Who already knows that? Who has these records? Do you actually know what's going on with your child health-wise, physically? Are you involved enough to know that? And if you're disinterested, that's not going to count very well towards you, right? You want to be interested. You want to be able to show that, yes, I am serious about this. I'm serious about my child. I know everything that's going on with my child, and boom, here it is. Community ties, including school, church, friends, who can talk about that. Now, let's say that the both of you already share there's no one leaving the house right now. You're already in two different homes. If both of you can show that your child is well connected with that community that you're in, again, that's going to lean towards 50-50, right? It's not going to be an unequal time sharing. 13, the least disruptive placement alternative for the child. So when they say placement, that means who's going to be the primary parent, like whose house is going to be the main house. If being in both houses will not be disruptive, because you may say yes, right? The child only knows his home, has always known this home. Even the other parent always comes here to visit with the child. That leans in your favor. But if the child was always going back and forth, that's not going to lean in your favor, right? And vice versa. 14, the child's wishes and long-term goals. So with that one, it's going to rely on age, right? Because a little baby or very young children are not going to really be able to provide that. And the courts start taking it when they're a little older. Unless you can prove that your child is exceptional. Your child is not the average 6-year-old, 8-year-old, or 10-year-old. They can really make an assessment. They have goals in place. Like there's a plan to do this. Like they're into soccer, and it's not just the regular Saturday soccer. There's a whole plan that they're going to be playing soccer. Then after they play it at this point, they're going to start teaching soccer. And then after they start teaching it, they're going to go and do, like an internships here and all that. That's a little different, right? Because that's a fully well laid out plan. So to take them from that environment and to put them in a new home, that's not going to weigh in favor of that individual. And 15, it's kind of all inclusive, because you're not limited to these. You can bring up something that you believe is very important, and you make that one of the factors. That's a thing too. Make it one of your factors. Okay, so any evidence of family violence, substance abuse, criminal history, sexual, mental, or physical abuse in any current, past, or considered home for the child. Okay, so we kind of touched on that, but it's just kind of trying to encompass everything. So anything else that is unhealthy, anything else that does not go, that we would not believe or a court would not believe is the best interest of the child, that's where we are, okay? That's the factor. So those are the top 15 factors. I hope that I covered all. I did, right? Okay. Yes. Okay. Yeah. So give it all 15. So that is what the court is going to consider. I understand, like I said in the beginning, that you feel like, listen, I know better than some judge. But the moment that you bring a third party in, you guys cannot agree together. You have now granted the court the license to participate in this process. And because they are not in your home with you, they cannot see everything you see. That's what they're going to rely on. What you need to do now is make sure that you understand these, make sure that you position yourself to be able to provide the evidence to prove why any one of these factors lean in your favor or goes against the other parent, okay? You want to bring it up, not out of it being vindictive, not just because they have a new girlfriend, because that's not a thing, right? Oh, there's a new girlfriend, there's a new boyfriend. I don't know them, so I don't want them to go there. That's not enough. You can ask, if it's an adult, you can ask for their name, their date of birth, and you can do a criminal history on them. And if you do find something that's unfavorable, then you can say, as long as that person is living there, not visiting, living there, then no, my child should not be able to go there. And the court will consider that, okay? So those are the factors all the courts consider, plus a little more, and other things that you can bring up, that all of the courts, we're talking about all 50 states, they consider these factors to determine the best interest of the child and who the child should be with, how visitation should go. And remember, they start at 50-50. So in your mind, you got to start at 50-50. You use these factors to see, will it weigh in your favor? Will it weigh in the other parent's favor? Or will it remain a 50-50? And that's how you lead yourself with true facts. That's how you're strategic versus being emotional in the subject of time sharing in custody of your child. So I'm Attorney J. Don't forget to subscribe, hit the notification button, and like, share. If you know anyone where this will help them with this information, then I want you to share it. I pray that you have a wonderful, whether you're watching this morning, noon, night, you have a wonderful rest of your day. God bless you. God has a purpose for you. There is life after divorce. Do not allow your emotions to prevent you from participating in your divorce process. This is important for your purpose, okay? We want you to be able to fulfill your God-given purpose even after your divorce. God has not given up on you. Divorce should not bring you shame. It should not bring you fear. If it is a necessary step, then you are taking a step to get to your next chapter, okay? It is not the end of the story. It is the beginning of a new chapter. See you in the next video.